Chapter 22. Fraudulent Chattel Mortgages. SS 347. Chattel mortgages. Questions affecting the validity of chattel mortgages as against creditors are so largely dependent upon and regulated by local statutory provisions that the general principles governing the subject can be discussed with but little satisfaction. Such mortgages are, as a general rule, valid between the parties, even though not recorded, and recording the instrument is made by statute in some states a substitute for change possession, and repels the imputation of fraud which would arise from the retention of possession by the vendor. Many questions concerning the validity of these instruments are to be found in the reports, only the more prominent of which will be noticed. SS 348. Rule in Robinson v. Elliott, the Supreme Court of the United States, in Robinson v. Elliott, committed itself unreservedly to the doctrine that an instrument which provided for the retention of the possession of the mortgage personalty by the mortgagor, accompanied with the power to dispose of it for his own benefit in the usual course of trade, was inconsistent with the idea of a security, or the nature and character of a mortgage, and of itself furnished a pretty effectual shield to a dishonest debtor, and consequently should be regarded as voidable as to creditors. Davis, J., said, in truth, the mortgage, if it can be so called, is but an expression of confidence, for there can be no real security where there is no certain lien, whatever may have been the motive which actuated the parties to this instrument. It is manifest that the necessary result of what they did do was to allow the mortgagors, under cover of the mortgage, to sell the goods as their own, and appropriate the proceeds to their own purposes. And this, too, for an indefinite length of time. It must be remembered that, in Twin's case, where the transfer was avoided, one of the objections urged against the transaction was that the debtor used the goods as his own. Mr. Pierce observes, a mortgage or conveyance of this kind presents a false appearance, is only a pretense, as a mortgage is calculated to deceive, cannot fail to deceive if it be operative, furnishes unusual facilities for fraud, reserves benefits to the grantor, and prejudices other creditors. When it thus appears that the transaction is, in its results, so fraudulent and so injurious to creditors, that few transactions could be more so, even where an intent to defraud exists so as to bring them within the statute of 13 Alis, the courts are as ready to adjudge the transaction fraudulent as they would be if a fraudulent intent appeared. SS 349. In Edgell v. Hart, the license to sell was inferred from a written schedule attached to the instrument. Chief Justice Denio held, with the concurrence of a majority of the court, that the existence of such a provision out of the mortgage or in it would invalidate it as matter of law, and that where the facts are undisputed this court should so declare. Such an agreement, said Finch, J., opens the door to fraud and permits the mortgagor to use the property for his own benefit, utilizing the mortgage as a shield against other creditors. The debtor, in the language of Kent, sports with the property as his own in Mittenacht v. Kelly. Parker, J., observed, the mortgaging the whole stock in trade, with the increase and decrease thereof, and the providing for the continued possession of the mortgagor, can have no other meaning than that the mortgagee should all the time retain a lien on the whole stock by way of mortgage, the mortgagor making purchases from time to time, and selling off in the ordinary manner, the intent being not to create an absolute lien upon any property, but a fluctuating one, which should open to release that which should be sold and taken what should be newly purchased. This is just such an arrangement as was held in Edgell v. Hart to render the mortgage void. The case cannot be distinguished from that, and the law as pronounced in that case must be held applicable to this. In Griswold v. Sheldon, Bronson, C.J., says, there would be no hope of maintaining honesty and fair dealing if the courts should allow a mortgagee or vendee to succeed in a claim to personal property against creditors and purchasers, after he had not only left the property in the possession of the debtor, but had allowed him to deal with and dispose of it as his own. To attempt, says Mr. Pierce, to fasten a valid and certain lien upon goods which may at any moment, at the will of the debtor, fly out from under the lien, is to attempt a legal and moral impossibility. It is a sham, a nullity, a mere shadow of a mortgage, only calculated to ward off other creditors, a conveyance and trust for the benefit of the person making it, and therefore void as against creditors. SS 350. Proof extrinsic to the instrument. The rule, as we have seen, is the same, whether the agreement is recited in the instrument or is extrinsic to it. Thus Allen, J., remarked, whether the agreement is in or out of the mortgage, whether verbal or in writing, can make no difference in principle. Its effect as characterizing the transaction would be the same. The difference in the modes of proving the agreement cannot take the sting out of the fact and render it harmless, if it is satisfactorily established. The result upon the security must be the same. When not embodied in the instrument, the agreement to sell must be proved. The mere expectation of one party or the other that this right is to be given is not enough. There must be a conscious assent of both. In Potts v. Hart, Earl J. said, "A mortgage thus given is fraudulent and void as to creditors because it must be presumed that at least one of the purposes, if not the main purpose for giving it, was to cover up the mortgagor's property and thus hinder and delay his other creditors. It matters not whether the agreement that the mortgagor may continue to deal in the property for his own benefit is contained in the mortgage or exists in peril outside of it. And where the agreement exists in peril, it matters not whether it is valid so that it can be enforced between the parties or not, for whether valid or invalid it is equally effectual to show the fraudulent purpose for which the mortgage was given, and the fraudulent intent which characterizes it. It is always open to creditors to assail, by peril evidence, a mortgage or a bill of sale of property as fraudulent and void as to them, while between the parties the written contract may be valid, and the outside peril agreement may not be shown or enforced, yet it may be shown by creditors for the purpose of proving the fraudulent intent which accompanied and characterized the giving of the written instrument. It is usually difficult to prove by peril an agreement in terms that the mortgagor may continue to deal in the property for his own benefit. Parties concocting a fraudulent mortgage would not be apt to put the transaction in that unequivocal form, but all the facts and circumstances surrounding the giving of the mortgage, and the subsequent dealing in the property with the knowledge and assent of the mortgagee, may be shown, and they may be sufficient to justify the court or jury in inferring the agreement. And so the peril agreement was inferred in all the cases which have come under our observation. SS 351. Comments in the cases. Chief Justice Parker, in speaking of these shifting liens, observes that if this doctrine were admitted, a mortgage of personal property would be like a kaleidoscope, in that the forms represented would change at every turn, but, unlike that instrument, in that the materials would not remain the same. The objection may be restated, to the effect that the mortgagor may dispose of the property, defeat the mortgage, and put the money in his own pocket. But if he refuses to pay a debt, and creditors seize the property in execution against his will, the mortgage steps in and restores it to the debtor. Again, it is said that there is no specific lien, but a floating mortgage, which attaches, swells, and contracts as the stock in trade changes, increases, and diminishes, or may wholly expire by entire sale and disposition, at the will of the mortgagor. Such stipulations are not only inconsistent with the idea of a mortgage, but tend inevitably to give a fraudulent advantage to the debtor over his other creditors. SS 352. Opposing rule in cases. The rule embodied in Robinson v. Elliott has, however, been a subject of much discussion and dissension. It seems to be conceded in the great mass of the cases that an agreement for the retention of possession, with power of disposition by the mortgagor, may constitute evidence of fraud, proper to be considered by the jury or the court as a fact in connection with all the circumstances arising in each particular case. The contention against the rule in Robinson v. Elliott is that the agreement does not render the instrument void per se, or as matter of law, or conclusively fraudulent, and that whether it is fraudulent in fact or not should be decided upon all the evidence, including, of course, the terms of the instrument itself. SS 353. Lowell, J. seemed to doubt both the generality and the justice of the rule stated by Davis, J. in Robinson v. Elliott, and regarded the doctrine as substantially settled, that when a vendor or mortgagor was permitted to retain the possession and control of his goods and act as apparent owner, the question whether this was a fraud or not was one of fact for the jury. The court observed, a conveyance for a valuable present consideration is never a fraud in law on the face of the deed, and if fraud is alleged to exist, it must be proved as a fact. It is considered plain that the doctrine of Robinson v. Elliott virtually prevents a trader from mortgaging his stock at any time for any useful purpose, for if he cannot sell in the ordinary course of trade, or only as the trustee and agent of the mortgagee, he might as well give possession to the mortgagee at once and go out of business. It is to be noticed that the court by this sentence expresses the belief that shifting liens upon merchandise, which open and close at the will of the mortgagor, are not necessarily fraudulent contrivances devised to defeat creditors. On the contrary, such mortgages seem to be contemplated as capable of subserving a useful purpose. Many of the cases, however, which follow Brett v. Carter, in holding that fraud is a question of fact, concede, and often expressly state, that contrivances of this class are convenient covers for fraud upon creditors. It seems to have been admitted in Brett v. Carter that there was no fraud in fact, as it is commonly termed, that the transaction showed that all the stock, present and future, was hypothecated to the payment of a certain debt by installments. No offer is made, said Lowell J., to prove that anyone was deceived or even was ignorant of the mortgage, but I am asked to find fraud in law, when I know, and it is admitted, there was none in fact. The court cites Mr. May's treatise as authority for the statement that fraud is a question of fact, but omits to note that the learned author was on the page cited discussing the question of the effect of the simple retention of possession, and fails to notice the following observation. The rule seems to be that where there is an absolute conveyance, and the grantor remains in possession in such a way as to be able to use the goods as his own, it is always void against creditors, even though made on valuable consideration. SS 354. Discussion of the principle involved. It is foreign to our design to kindle the smoldering embers of this discussion into new flame. It will be seen at a glance that the subject matter of contention in the controversy is the much debated distinction between fraud in law and fraud in fact. The conclusion is reached in our opening chapter, that this distinction is largely mythical, and relates only to the character and quantity of the proof adduced to nullify the transaction, where the evidence is of such a conclusive nature that the fraudulent intent unmistakably fastens its fangs upon the transfer, so that a verdict or finding contrary to the evident evil design so established would be erroneous. The court pronounces the transaction covenous, and imputes the fraudulent intent to the parties in obedience to the principle of law that they must have contemplated the natural and necessary consequences of their acts, where the facts are not controverted and do not admit of a construction consistent with innocence. Surely the burden is cast upon the court to declare the result. There is no question of intention to be submitted to the jury, as the mortgage shows upon its face that it was not designed by the parties as an operative instrument between them. Its only effect is to prejudice others. The court should pronounce it void, for the reason that the evidence conclusively shows it fraudulent. It is because such trusts are calculated to deceive and embarrass creditors, because they are not things to which honest debtors can have occasion to resort in sales of their property, and because they constitute the means which dishonest debtors commonly and ordinarily use to cheat their creditors, that the law does not permit a debtor to say that he used them for an honest purpose in any case. Chief Justice Ryan said, "Intent does not enter into the question. Fraud in fact goes to avoid an instrument otherwise valid, but intent, bona fide or mollified, is immaterial to an instrument per se fraudulent and void in law. The fraud which the law imputes to it is conclusive. Fraud in fact imputed to a contract is a question of evidence, not fraud in law, and no agreement of the parties in peril can aid a written instrument fraudulent and void in law." SS 355. Authorizing sales for mortgagees' benefit. 3 cases, decided in the New York Court of Appeals in rapid succession, and recently approved in the same court, held that a chattel mortgage was not per se void because of a provision contained in it allowing the mortgagor to sell the mortgaged property and account to the mortgagee for the proceeds, and apply them to the mortgage debt. These cases, says Finch, J., when upon the ground that such sale and application of proceeds is the normal and proper purpose of a chattel mortgage, and within the precise boundaries of its lawful operation and effect, it does no more than to substitute the mortgagor as the agent of the mortgagee, to do exactly what the latter had the right to do, and what it was his privilege and his duty to accomplish. It may be observed that a subsequent judgment creditor is entitled to have an account of the sales so made stated, and to have the amount thereof applied to reduce the mortgage debt. SS 356. Sales upon credit. The rule being established that the mortgagor may sell the property and account for the proceeds to the mortgagee, and that such an arrangement is not fraudulent in law if made with an honest intention. Another phase of the controversy must be considered. What will be the effect if the mortgagor is not restricted to sales for cash, but is allowed to sell upon credit? In his discretion elsewhere, it is shown that general assignments permitting the assignee to sell upon credit are regarded as fraudulent, because such agreements hinder and delay creditors and prevent the immediate application of the debtor's property to the payment of their claims. The same principle has been extended and applied to sales of the mortgaged property made upon credit by the mortgagor for the mortgagee. The arrangement is calculated to keep the creditors at bay, and is regarded as fraudulent per se. If, however, the accounts, where the sales are effected on credit, are immediately transferred to the mortgagee at their face, and credited or allowed upon the mortgage debt, The objectionable elements of the transaction are eliminated, and the arrangement will be tolerated. In Brown v. Guthrie, Finch, J. said, the dealing, therefore, must be treated as a chattel mortgage by the debtor to his creditor, the consideration of which was evidenced and settled by the outside agreement. So regarded, the findings declare it to have been in good faith and not fraudulent. The arrangement for the sale on credit was made harmless by the stipulation that Guthrie should take the credits as cash, and himself bear the delay, and risk the solvency of the purchasers. SS 357. Possession, independent valid transactions. Selling or taking possession of the property under and by virtue of the fraudulent mortgage cannot, of necessity, purge it of the vice of fraud. The title remained fraudulent and voidable still as against creditors, before and after taking possession. The title of the mortgagee rests equally upon the mortgage, and the question, as regards creditors of the mortgagor, is the validity of his paper title. The mortgagee's possession under the mortgage is as good or as bad as the mortgage itself, and the court has not the power to transmute a void mortgage into a valid pledge. But even in cases where the mortgage is fraudulent, if the mortgagee repudiates the instrument and casts it aside, and obtains a pledge of the goods accompanied by delivery and an open change of possession, and by a distinct agreement subsequent to and independent of the mortgage, his rights will be protected as against the other creditors. SS 358. Right of revocation reservations. We have seen that a debtor, before any lien attaches in favor of creditors, possesses the right to make any disposition of his property. The contract, however, by which he parts with it must be absolute and unconditional, for if he retain the right to revoke the contract and resume the ownership of the property, the reservation is considered as inconsistent with a fair, honest, and absolute sale, and renders the transfer fraudulent and void. In the great case of Riggs v. Murray, in which the various instruments of transfer contain powers of revocation, Chancellor Kent held the transfers void, saying that there was a necessary inference of a purpose to delay, hinder, or defraud creditors, that the only effect of these assignments was to mask the property, and that such powers of revocation are fatal to the instrument and poison it throughout, appears to have been well established by authority. So a deed reserving the right to the grantor to sell and convey the property without the consent of the grantee is inconsistent with the idea of a sale, and may be avoided by creditors. SS 359. Rule as to consumable property. The mortgaging of property, the use of which involves its consumption, is an evidence of fraud of much weight. Unless satisfactorily explained, it will cause the condemnation of the instrument. Of course, articles in their nature subject to be consumed in their use may be mortgaged without any imputation of fraud, provided they are not to be used, and may be kept without damage until the mortgage debt shall become payable. If, however, the mortgage covers articles which would perish or be destroyed before the debts secured by the mortgage mature, it becomes manifest that the object was not to apply these things to the payment of the mortgage, but to secure the debtor in their possession and enjoyment.